Hello, my name is Charles Pratt. I'm a judge with the Allen Superior Court Family Relations Division. Please pay close attention to the advisory of rights that follows. A report, known as a preliminary inquiry report, has been filed by the Department of Child Services. The department is asking the court to find probable cause that the child or children named in the report are children in need of services, often referred to as CHINs. Indiana Code 31-34-1 and the statutes that follow define the type of factual situations that can result in finding that a child is a child in need of services. You will be provided a copy of that report. The court will conduct an informal hearing known as a preliminary inquiry to determine whether probable cause exists to believe that the child or children are children in need of services, and whether or not the department should be given the authority to proceed with the case by filing a petition. If the court authorizes the department to file a petition, then an initial hearing will be immediately held, and you will be served with a summons, a copy of the petition, and a notice of the next hearing. The court may issue temporary orders placing the child or children in a parent's care, with a relative, in licensed foster care, or in shelter care. The court may restrict a parent, a relative, a guardian, or a custodian's contact with the child or children. The court may require the parent, guardian, or custodian to begin services provided by the department. The court may also issue additional orders to protect the safety, well-being, and best interest of the child or children. A guardian ad litem or court-appointed special advocate will be appointed for the child or children. A guardian ad litem or CASA volunteer represents the child or children's best interest throughout the court process. An additional initial hearing will be scheduled in about 20 to 30 days. Prior to that hearing, the department will file an amended petition that sets forth the specific allegations that the child or children are children in need of services. You will be provided a date and a time for the additional initial hearing. It is important that you arrive on time. If you fail to appear, the court may conduct the hearing without you. Immediately before the additional initial hearing, you will participate in a meeting known as facilitation. Facilitation is a process designed with the support of Indiana's Court Improvement Project. An independent facilitator will lead a discussion to determine if an agreement can be reached as to whether the child or children are children in need of services, where the child or children should be placed, the parental contact with the child or children, and what services should be provided to the family. The discussion at this meeting is confidential, and only the agreements reached or the disagreements that need to be decided by the judge will be reported to the court. You, your attorney, the court-appointed special advocate or guardian ad litem, and the Department of Child Services caseworker and attorney will be present at the facilitation. We encourage you to invite family members and other supportive persons to this meeting. If an agreement that the child or children are children in need of services is not reached, then a trial called a fact-finding will be scheduled. At the trial, the department must prove that the child or children are in need of services by the preponderance of the evidence. You have a right to cross-examine witnesses, obtain witnesses or tangible evidence by compulsory process, and to introduce evidence on your own behalf. You also have a right not to make any statements that may incriminate you in any other court proceedings. If the child or children are found to be children in need of services, then the court will conduct a dispositional hearing. At this hearing, the court will order supervision of the child or children by the Department of Child Services. The court may order the child or children placed in the care of the custodial parent, the non-custodial parent, with a fit and willing relative, licensed foster care, shelter care, or in a residential treatment facility. The court may order that the child or children receive inpatient or outpatient treatment through a social services agency, psychological, psychiatric, medical, or educational facility, or from an individual practitioner. The court may order that the child be emancipated. The court may order the parent, guardian, or custodian to enroll in and to participate in services through a parent participation plan. The court may also restrict or prevent contact with the child or children by any person, including a parent, and prevent the child from leaving the court's jurisdiction. The court may order a parent to financially contribute to the cost of the child or children's care. And until the case is concluded, the court will hold review and permanency hearings at a minimum of every 6 months to review the progress of the family. If a parent or guardian or custodian fails to participate in the ordered services or is not willing or able to benefit from the required services, then the department may file a separate case and the court could terminate parental rights. You have a right to an attorney. If you cannot afford an attorney, one will be appointed for you. You have a right to receive notice of all the hearings being held in this case. To ensure that you receive notice, you must provide the department with all of your contact information throughout the time the case remains before the court. You may dispute any allegations made at any of the hearings and may dispute your financial responsibility or your participation in services. You have a right to free access to interpreter services should you have language or physical barriers to your meaningful participation in the hearings. You have a right to appeal the finding that the child is a child in need of services. A child in need of services case is not a criminal case. It is a civil case, and it is designed to provide protection for children and to provide families with services to assist them in correcting issues that they may be experiencing. The court understands that most cases involving children impact the entire extended family. Therefore, this court welcomes and encourages the participation of family members and other supportive persons in all court proceedings.